Welcome back to Eyewitness News. Our legal counsel, Charlie O'Hara, here in the studio today. 436-1212 is the number to call, and we have callers already lined up, ready to talk to you. Thanks for being here.
Good to be here.
We'll get to the phones. All right, caller, what's your question for Charlie today? Go ahead, caller. What's your question?
Yeah, you have a will, and you have somebody, I mean, I hadn't made a will out, but anyhow, I'd like to be interested in making a will out, and I have a house, and it's paid off, and I want to will to somebody out of state. What's the procedure on that?
Well, I think that the best thing to do anytime you have a will is actually to go to an attorney that writes wills. They're usually not very expensive. If you don't have a lot of property, it's a relatively simple will, but the attorney can tell you how to do everything correctly. And I think there's a lot of misunderstandings, and we have these things on TV where they say you can make your own will. Kansas doesn't really like that very well. It's better to have an attorney do that. And so I would advise you, even for if your house, that's got to be an asset, and some other things. I think you ought to go to an attorney, tell them what you want to do. You can will things to people out of state. You can do whatever you want with a will, and a lot of people do different things with a will that sometimes the people alive don't like. But you can actually do basically whatever you want. So I would advise you go to an attorney and get that all straightened out. It shouldn't cost you very much.
You just want to make sure it's done correctly.
That's correct.
Okay.
That's right.
Thank you, Charlie. All right, go ahead, caller. What's your question for us today?
Yes, I have a order for visitation for grandparents' rights. It's been agreed to by my daughter. I'm not receiving my grandparents' visitation, so I'm having defiance of the visitation agreement. Can you tell me what my rights would be as far as enforcing that agreement, and what would be a good thing for me to do next to do that?
Well, I'd actually have to see the agreement before I could clearly answer that, but if the agreement is signed by a judge as an order of the judge and your daughter's not following the order of the judge, she's in violation of that order. That's contempt. So you need to go to court, and the judge will enforce the order, whatever he has to do. If a judge orders something, we're supposed to follow it. As attorneys, if a judge orders something, we have to do what the judge says. The people in court have to do what the judge says. If we don't do what the judge says, the whole system will fall apart. So when a judge orders something, you're supposed to follow it. If you don't like it, you can appeal. But if the judge orders it, you're supposed to follow it. So in that case, you got to go to court and enforce the order. Kind
of like when we were talking about probation the other day. It's black and white. There's not much of a gray area there.
Well, it actually is black and white. There's a lot of gray in the law. I mean, even though you may have technically violated your probation or technically not done what the judge said, there may be an explanation, too. That's why people get frustrated with the law that aren't lawyers. It's awfully hard to understand. But if the judge orders something, you got to do what the judge says.
Okay.
That's right.
Thank you, Charlie. All right, we do have one more caller on the line for us today. Go ahead, caller. What's your question? Go ahead, caller. What's your question for us?
My question is, I recently got married about 4 years ago.
We're still here.
My husband had children from a previous marriage, and his house was willed to them.
So you wonder about the will?
So I wonder if getting married cancels that will according to his house.
I don't know that it cancels it. It may change the whole dynamic. The best thing for him to do, as I told the previous caller, is to go to an attorney and get it straight. Although some of these things seem simple, just if you have a house and some kids, you can usually write a real simple will, and it's worth the money to do that so it's done correctly. So in that instance, I think what your husband needs to do is go have a new will made, doing what he wants to do today, since his circumstances have changed and he's gotten married. The other will still has some effect, but then you get into all sorts of legal issues. It's much better to get them straightened out before someone passes away.
Okay. Thank you, Charlie. We appreciate you being here today.
Sure.
Great questions and great answers.
I don't know about that. Thanks.
We'll see you next time.
Okay.